Chairman of the Bar Council, Sri Durga Prasad Rao, and other members, and the distinguished advocates from the nook and corners of the state of AP, and to my knowledge, the faculty and some of the students of the distinguished university. At the outset, the post-lunch session is a curse, isn't it? More so if it is coupled with a sumptuous lunch and taxed with a jarring and a prolonged subject like partitions, a vintage subject. But Durga Prasad Garu punished me, and you also. We have to bear with him. We will try to live up to the expectation, because the subject which is assigned to me, the partition suit nuances, and also the next subject, the testamentary and interstate succession, which is assigned to my brother Sri Prasad Rao Garu, have some similarities. We thought it fit to gain some time and also to sustain the tempo. Wanted to avoid the repetitions, and both of us together will take the subject one after another. Please bear with us. First of all, so far as me is concerned, the salient features of the partition suit. This subject is concerned because, as I told, it is a long subject. You might have felt it while doing trial work as a trial advocates partition suits. Because of the nature of the subject, we have to deal with the different allied subjects like Transfer of Property Act, Specific Relief Act, Contract Act, sometimes while doing the partition suits. And also the personal law, because we are now concerned with Akshara co-personal property and partition suits relating to Hindus. You have to incidentally deal with the personal laws. And the nature of the suit is such that the preliminary decree would be passed, then final decree petition will be filed, and that will also be inquired into by the trial court, and ultimately final decree will be passed, and thereafter the execution will be taken in accordance with the drafted final decree. So the subject theoretically as well as practically a lengthy one, isn't it? So where to start the partition suits, and that too in a limited time? Let us divide the subject into three aspects which I thought it fit. The persons who are entitled to seek for partition, this is the first aspect of our discussion or interaction. The persons who are entitled to seek for partition, again, this has to be divided, subdivided. Pre-1956 era and post-1956 era, that is, before the advent of Hindu Succession Act 1956. And the persons who are entitled to seek for partition after the advent of 1956 enactment. This classification, most of you know, is necessary because 1956 enactment, Hindu Succession Act 1956, which was introduced on 17th June 1956, has brought a radical change in the aspect of eligibility of the persons who seek for partition. Therefore, if we deal with a topic as to who are entitled to seek for partition, we have to vertically classify them into two groups. One group who are entitled to seek for partition pre-1956 era, who are entitled to, or who are more people who are entitled to seek for partition after 1956. This is the first class, the first aspect. The second one is some third parties will also come as interlopers in the aspect of partition you may simply say the third party purchases, is not it? What are the rights and liabilities? How they are affected by the general partition among the co-partners and co-sharers. That is also an aspect we have to look into. And third one is, of course, procedural one relates to the passing of the preliminary decree, then conducting inquiry with regard to the final decree, and passing of the final decree and execution. This is procedural one. What are the changes that have been brought by virtue of the different judgments, particularly that of the Supreme Court? So this is the third segment or the third aspect we have to deal in the context of the partition suits. So far as the testamentary succession is concerned and other allied aspects are concerned, I hope my brother Prasad Rao Garu will take up, and if anything I forgot or I wanted to take, he can carry it out. This is how we want to dispute between us with regard to the basic subject, that is partition suits. Please bear with us. The first one is with regard to the first aspect of the partition suits, as I told you, who are entitled to seek for partition prior to 1956, is not it? The first division of the subject. Before discussing this aspect, we have to also know how the aspect of the partition came into force. Primarily, the Hindu family or Hindu society with which we are now concerned was a joint family. We lived in gregariously, we lived in flocks. The society lived in groups or in joint families. Why? Because the economic conditions, the avocations they undertaken permitted them to live in joint families rather than individually. Ours is an agricultural oriented country. Economically, even now also, we depend on agriculture, horticulture, animal husbandry, or the other avocations like cobblers or the goldsmiths or blacksmiths, fishermen. All these avocations need a group or collective efforts. Perhaps that was the reason why the people in India throughout the length and breadth of the country used to live in joint families and pursuing their avocations. And whatever income they earned individually was thrown into the common stock called as common hodgepodge, you may call it technically.